Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, this is going to be a video for the hometown crowd. This will be the first in a two-part series on this particular bill. And this bill is a doozy. It was introduced last week. It has some of the usual suspects all over it. But this bill is absolutely the most nefarious, sinister, and in fact, dystopian form of legislation we have ever seen. And I'm not making it up. If you thought Senate Bill 5078 was designed to put the FFLs out of business last year, you haven't seen anything yet. This bill is absolutely positively designed to put FFLs out of business. That is the exact purpose of it. And if enacted into legislation, it will accomplish just that. So today, let's start getting you educated about Washington's most dystopian gun control law yet. Okay, so the bill we're talking about today is House Bill 2118. It was just introduced late last week. It is sponsored by Representatives Whalen and, of course, that's right, your favorite gun grabber, Liz Berry. Now, we know that whenever Liz Berry is involved in drafting legislation, what she has done, it's kind of the Claudia Gay way of doing things, is she just cuts and pastes from somebody else's statutes. What am I talking about? Well, this bill is already codified in California as California Penal Code 26806. It just went into effect January 1st as part of California Senate Bill 2. It is also subject to a massive lawsuit in the matter of Richards v. Newsom. What this bill does is it will dictate to every single FFL how the physical structure of their building needs to be maintained and actually constructed, and will require 24-hour, 7-day-a-week, 365 video surveillance, and requires the gun dealers to store all of this video for a lengthy period of time. Translation: this would basically force FFLs to incur hundreds of thousands, if not millions of dollars in expenses to stay in compliance with this piece of legislation if it is enacted into law. Now, we're only going to talk about a couple of the parts of the bill today, and I'm going to do a second video later in the week because that's how bad this bill is. But when I say that we're going to now mandate to FFLs how, in fact, their buildings need to be constructed, this is what I mean, because the bill specifically states, the business building location designated in this license shall be secured, 1, with at least one of the following features designed to prevent unauthorized entry, which must be installed on each exterior door and window of the place of business. A, bars or grates. B, security screens. Or C, commercial grade metal doors. And 2, with the security alarm system that is A, properly installed and maintained in good condition, B, monitored by a remote central station that can contact law enforcement in the event of an alarm, C, capable of real-time monitoring of all exterior doors and windows and all areas where firearms are stored, and D, equipped with, at minimum, detectors that can perceive entry, motion, and sound. Now, I know that many FFLs have some of those safety features in place. Other FFLs, based upon their geographical location and things like that, may not have all of those security measures in place. I firmly believe that security measures are kind of based upon the store's location and what is in the best interest of that particular community. Of course, Liz Berry knows way better than all of you about what's best for you. But you could understand, especially for these small independent operations that are serving rural communities. Think of Guardian Arms over in Moses Lake. Okay, think of 3 Aces over in Spokane. Places like that, Hole in the Wall in the Tri-Cities, right? Some of these small independent operations, you start making them incur even $30,000, $40,000 worth of expenses to retrofit their building, yeah, no bueno, they're out of business. Then comes the most dystopian part of this law, and this is the part that is really the big subject of the lawsuit in California, because this is literally written right out of George Orwell's 1984. So whoever was the original drafter of this legislation, which we know was not Liz Berry, obviously cut and pasted from George Orwell, because this legislation would now require 24-hour, 7-day a week, 365-day video surveillance of all portions of the building. That's including during non-business hours, and then that video needs to be stored. And I'll explain that problem in a moment, but this is how the legislation reads. A dealer shall ensure that its business location designated in the license is monitored by a digital video surveillance system that meets all of the following requirements. So remember, it has to meet all of the following requirements. Now, many of these operations obviously have some kind of video surveillance, video security type system, but now you have to meet all of the following requirements, and they include: 1, the system shall clearly record images and, for systems located inside the premises, audio of the area under surveillance. 2, each camera shall be permanently mounted in a fixed location. Cameras shall be placed in locations that allow the camera to clearly record activity occurring in all areas described in A3 of this subsection and reasonably produce recordings that allow for clear identification of any person. And then this is all the areas that have to be video and audio recorded. The areas recorded shall include, but are not limited to, all of the following: A, interior views of all exterior doors, windows, and any other entries or exits to the premise. B, all areas where firearms are displayed. And C, all points of sale sufficient to identify the parties involved in the transaction. And then here's where the money really piles on, because the legislation would also require: the system shall continuously record 24 hours per day at a frame rate no less than 15 frames per second, which means you're talking about pretty decent recording equipment. But then, you see, they want you to store all of that video. This is what the legislation states. The media or device on which recordings are stored shall be secured in a manner to protect the recordings from tampering, unauthorized access, or use or theft. Recordings shall be maintained for a minimum of 6 years. Recorded images shall clearly and accurately display the date and time. So obviously some of our more concerned FFLs in the industry, the Dan Mitchells down at Sporting System, the Tom Matoses at Security Gun Club, they've already started going out and looking at what kind of a storage system you would need to store all of that digital data. And folks, we're running around $200,000 for one server to store that much video evidence. Okay, so there's 2 more things I want you to be aware of about in this legislation, because in addition to basically enforcing this George Orwellian style of Big Brother monitoring, then the gun stores will be required to put up a sign. And this sign is absolutely positively designed to have a chilling effect on people's willingness to do business, which again is another subject of the lawsuit in California, because the legislation reads: the dealer shall post a sign in a conspicuous place at each entrance to the premise that states in block letters not less than 1 inch in height: these premises are under video and audio surveillance. Your image and conversations may be recorded. Now, shockingly, many people just don't like to have their images and audio recorded. But the chilling effect comes from the fact that it would appear that the FFL has decided they want to do this. A more accurate description of what's going on, and therefore what the sign should say, is the following: warning, these premises, by order of the state of Washington, are under video and audio surveillance. Your image and conversations may be recorded. Okay, but here's the most important point that I want you all to be aware of. Do you see any exception in this bill for a home-based FFL? No, there isn't. And as a matter of fact, home-based FFLs usually outnumber brick-and-mortar FFLs 3 to 1, 4 to 1. Some people actually make their entire income by being a home-based FFL. Other individuals do it as a hobby or do it for other purposes. But there's absolutely no exception in this bill to that, which means if this becomes legislation, the state of Washington is going to force 24-hour, 7-day a week, 365 days a year video and audio surveillance inside a person's private residence, all because of the profession that they have chosen. The bill, once again, is House Bill 2118. We will go ahead and link it all up down for you below so you can start geeking out on it for yourself. You might want to grab a barf bag before you do it. Now, I told you we're going to be doing a second video because I haven't even gotten through all of the stuff in this thing. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. Now, in the meantime, I want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.